and 20 guys down at the crime lab working in shifts, on every single case. But that's not a reality. We have proven this, and they go on, they try to make excuses for why this wasn't done or was that wasn't done. And of course, you talk about the Constitution doesn't talk about, cutting them slack when they weren't able to do their job. Every person, whether it's a speeding ticket or a death penalty case, is entitled to due process, entitled to a full, fair, complete investigation. And this is where, I mentioned, proof beyond a reasonable doubt, and then we can talk about, this is our legal justice system in the United States. This is the best one in the world. Does it have its flaws? Absolutely. Would I want to be tried in any case in any other country? Hell no. But this is why. We put a high burden on the state of Texas when they are trying to condemn someone, when they are trying to take somebody's liberty. Do not fall for these excuses. This is, and this is my opinion. I don't flip through the jury charge too often. I don't talk about, reasonable doubt and use the step ladder. It's not me. It doesn't work for me. I just hammer and hammer and hammer what I brought out in cross-examination and let that speak for itself. Because this is what I believe. I believe that the jurors, I don't think that they go back in that room and they say, did they prove the case beyond the reason? I think that they go back in there and they say, do we think he's guilty? Raise your hand. Do we think he's guilty? Do I feel comfortable convicting this person? Given what we heard today. I oftentimes will tell them, beyond a reasonable doubt, that's legalese. That's lawyer talk. Okay? What we're going to talk about here is, is this man guilty of this crime? And oftentimes, and I will say this, he is not just not guilty, he is innocent of this crime. This investigation was ridiculous. They had opportunities not just to provide evidence of his guilt, but these same opportunities that we talked about, this same lack of getting DNA evidence, of processing clothing. These are all things that could have also proven the defendant didn't commit the crime. They have just as much responsibility to provide you incriminating evidence as they do providing you exculpatory evidence or evidence that he didn't do it. So make no mistake, I am not suggesting that any of this evidence would have pointed in the direction of my client, but it could have helped you be even more comfortable with the fact that she's innocent. And they didn't do that. Is it because they didn't want to know the answer to that question? Better leave that door closed because processing that evidence could have hurt them, could have been inconsistent with their theory of the case. We are not here in the jury charge. This is one time I may mention the jury charge. The defense doesn't have to prove anything to you. I'm just here to show you how the case against my client is wholly insufficient. And how they could have fairly easily made your job easier one way or the other. And they just didn't do it. There you have it. Thanks, guys. I appreciate your time.
Who come up. We did this a couple years ago.
There you go. You're clear.
7 different people doing closing arguments. And we did it in an hour and a half. And we went over then, too, in terms of the slated time. But we started a little bit late. And the last speaker we have is a lawyer who was trained by the legendary lawyer Jerry Spence, who was a graduate of the Trial Lawyers College and has tried numerous cases. And it's the public defender's own, T.I. Vabell. And I'd like to call T.I. Vabell up to give her presentation.
I will make this very short. I'm going to be honest with you. I'm not the most polished. I went to the Trial Lawyers College to become more polished and to say all the right things and to be this super lawyer I hadn't made. The thing I learned about closing arguments is the best thing to be is you. And all you have to do is you are. Sorry. The closing is the last chapter in your story. That's what the close is. You go in and you fight during the negotiation part. And you pick your jury. But if you haven't prepared your closing in your head before you pick your jury and you don't know what your arguments are going to be before you get to that point, you were screwed before you started. You have to know it. You have to know your facts. And I don't mean you read the offense report that they gave you. You go beyond that. You read the offense report, but you've been to the neighborhood yourself, and you talk to people that weren't the ones that were listed in the offense report, and you know them, and you know their stories, and you know the dirt that they do. You know it all. As defense attorneys, we have to be the most prepared people in the room. We have to have more knowledge of the facts than sometimes our clients and the prosecutors. But the closing is just the final chapter. When we give our closing arguments, everybody's will be different. When I first read Eric's introduction, I was just like, man, he put me on blast for crying, saying I'm a big crybaby. And, you know, for 2 seconds I was in my feelings, and then I thought, but that mess is true. I do. Not on every case, but there are some cases that get to you. There are some cases that stick with you. By the time you go to trial, you haven't met your client twice. You've met your client several times. You know your client's mother. You know what your client did, all the mess they got into, but you know more than just the worst thing that they've ever done. You know the person. On the ones that I know the person and I don't like the person, I generally try to switch it up and say, well, if this was my brother, or if this is somebody that meant something to me, what do I say? What do I do? If they did that, how do I feel? Our wins don't just come in the forms of getting the walk. Sometimes it's getting a lot less time. But our close takes us there. Y'all have sat through everybody, and people have talked about everything from the things you say into the things you don't say. What I will say is, don't do or say anything that's not you, because it comes across as inauthentic. And as much as they want to show, they want to believe that it's a show that you believe in. They want to believe that you are powered by your own passion and your own belief in your case. Not, I'm doing this so you can give me a win even if it wasn't one. When you start off your close, even on the impossible cases, I'm at the public defender's office. We get a lot of impossible cases. Ones we can't give back. I started off by looking at it from the standpoint of, what do I believe? What do I see? Let's be honest. The state, just like they breathe, they overcharge. It's just this is what they do. So, what do I think about this case? What do I believe? What can I sell? I can't sell anything I won't buy. If the client's story is absolutely ridiculous, we're going to have that conversation. You know that's stupid, right? You know nobody believes that, including you, right? And we map it out. I will fast forward through a lot of this because you have heard from people that have been doing this a lot longer than I have. And I'll take you to what I do for a closing. Everyone will be different. I don't think there's one time in life I've written it down on a sheet of paper and planned it out and it just did not go so well. What I bring up to me with me when I give a closing is a sheet. It's a sheet of paper that I've kept on hand while the trial was going on. It's what I call my piss me off sheet. When I'm looking down or the prosecutor says something and I know that that hurt my case, I look at the jurors and I see their reactions, it goes on my sheet. When they said something to make me mad, it goes on my sheet. When something pops into my head, it goes on my sheet. By the time you get up to close, you've read that sheet 1,000,000 times and you have it memorized. Just like you have the facts and your client and your argument and what you believe memorized. And you go for that, or at least I do. And it comes in the form of a conversation. So I'll get to my conversation. I watch your faces when you saw his body. I watched each and every single one of you. And I remember the minute that I first heard about this case, I wasn't in court. I was in my living room. And the thought that went to my head is, what kind of person could do something like that? And then I quickly turned the channel because my little girl was coming in the room. I understand what that can make you feel like. I understand the rage it brings because I had my own. We don't do these kind of things to other people. I'm not going to stand and tell you that he deserved this, because there is nobody that deserves anything like this ever. We do not do this to each other. I know it took me a while to get to where I'm going to ask you to go, and you've only had days. I'm going to ask you to stop for 1 second and put aside the rage and look at the facts. The facts in this case are clear. This happened to him. He was burned. Nobody should die like that ever. It was horrific, and it was done by a monster. The only question is, who is the monster? The state is going to get up and you will cry. They're going to tell you about his mother. They're going to tell you about his life here and how hard he tried and how it ended up. They're going to want your feelings to take you to a place their evidence will never lead you. But ask the hard questions, starting off by, what did he do? What was his part? What did he know, and when did he know it? Those things matter. Yes, I think this was bad. I know this was horrible. But what is worse is when we try to replace what we know we have lacking in evidence with if I get them hopped up on emotion and get them past the dispassionate deliberation process, I get my guilty, even if the evidence doesn't take us there. Because when you're no longer feeling sad and you're looking at this case for what it is and exactly what he did, and you're looking at just that question, you're going to get to the answer I got to. I'm just asking you to get there faster. The state is going to tell you that the state told you that this person saw him do this. And the other person said that they saw him standing in this location. What they never told you is he knew. He knew any of this would happen. They're not going to tell you that he played this part in it. They're going to tell you he was there. Now, don't get me wrong. I'm not going to sit here with a straight face and make an argument to you. He was totally innocent. He did nothing wrong. Shouldn't have been there. But that's not what they charged him with. And trust, the statute is not over. So what I want you to do is deliberate based upon the evidence that you have. And if the evidence doesn't take you there, because it does not, you'll get a chance to talk to the state. You'll be in a room with the state. You can tell them how this case made you feel, but you can also tell them to do their job and go after him for exactly what he did, because he did wrong, just not this. That's it.
Well, all right. Thank you, T.I. Bell. And I'm sorry? Oh, there are some evaluation forms that we have that you guys may have picked up. If anybody doesn't have them, we have some more of them here. We can pass them out. We'd ask you to please fill these out. And if you haven't already signed up for the credit, the CLE credit, please sign up. There are sign-up sheets at both of the back sections, and there's some here at the table. And just by way of information, again, April the 30th, 1986, was the date that the U.S. Supreme Court handed down the Batson versus Kentucky case. So April 30th, 2016 marks 30 years since the Supreme Court decided Batson versus Kentucky. So to that end, on April 27th, the Public Defender's Office is going to have a CLE on Batson versus Kentucky, on how to make a Batson challenge and how to preserve the era, issues associated with Batson challenge for purposes of appeal. And we'll give a little historical perspective on the Batson challenge. We've already had some confirmed speakers. Craig Washington is a confirmed speaker, along with Alvin Nunnery and Loretta Muldrow and Francis Boilio from our office is going to give an appellate perspective about the history of the law and development of the law. Please come out. It's a free CLE. I think it's 2.5 hours of CLE credit with a half hour of ethics. So if you need ethics credit and you need more CLE, we'd ask you to come out. And we want to say on behalf of the speakers that are here, thank you. Thank you. It should be. This is available. If it isn't available, we'll